Well, I guess the issue that we want to take up today is property. Property encompasses everything that we own, everything that we touch, everything that we use. And the word property on the street or in street vernacular and the word property on the courtroom floor are not synonymous terms. The word property is protected by your Constitution, and I want to point out here in our state Constitution, let's pick up our state Constitution of the state of Idaho in this lesson. Would you zero in on that? Let me show you the value of property and what our state founding fathers thought about property. You'll find it right here in Article 1, Section 1, very first page. And where it says Declaration of Rights, it says, inalienable rights of man. All men are by nature free and equal, and have certain inalienable rights, among which are enjoying and defending life, liberty, and acquiring, underline the word acquiring, would you please, possessing and protecting property, pursuing happiness and securing safety. Now, just what is property? You know, on the street, when you talk about property, you're talking about something like your house, your lot, your summer home, your farm, your ranch, and that's called real property. But property includes and encompasses so much more than that. It includes your car, your necktie, your shirt, your pen. And it not only encompasses those things, but it also encompasses rights. Are you aware that rights are property? And that property cannot be taken from you because it's an inalienable right? In this case of Hale versus Hinkle, pursuant to property, turn over here to page 20 with me, and let's run through the property section. We're down here at the bottom. Let's see if I can put my finger on it here. Yes, it is. Or yes, I can. Let's start off where it says his rights, about 2/3 of the way down. 1, 2, 3, 4, 5, 6, 7, 8. The ninth line up from the bottom. Ninth from the bottom. Page 20. Legal quotations. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property. See that? And his property. From arrest or seizure except under a warrant of the law. I'm going to introduce a couple of fellows here, Neelis Cook and Bob Halston. First of all, we want to talk about real property and how real property affects you and how to keep real property and whether or not you should pay property tax on your real property. Because, you know, if you're paying property tax on your real property, on your home, your farm, your cabin, or whatever it is, you don't own it. You are not exercising allodial freehold property rights on that property. The first question that comes up is if you don't pay the property tax, what happens? Well, your government comes in and issues a tax deed and sells it to some other serf, don't they? Well, then, there's proof positive that you don't own the property because it can be taken away from you. If it can be taken away from you and sold to some other serf, well, then you don't own it. You only rent it from the county or the state. And therefore, you have an equitable interest in the property, and you can use it, and you can live there. You can do certain things with it so long as the government allows you to do that. Well, that's no different than it is in the Soviet Union, except that they're not so hypocritical about it there. In the Soviet Union, they tell you this land belongs to the state, and you have an equitable interest in it so long as we'll allow you to live here. And if and when you do not specifically perform pursuant to the way we tell you to specifically perform, we'll throw you out of it and put some other serf on it. Would you please tell me what the difference is between the Soviet Union and the United States? The only difference I see is in the name and in the form of the feudal tenure on the land, also known as feudal serfdom. That came to us out of the Middle Ages, and it's been enforced upon us by these international bankers and the monetary policy and the loss of our common law with HJR 192 in 1933. We don't have a common law because we don't have any substance. And so without substance and without the common law, the government then has simply asserted or usurped your powers and has just claimed all of the land, including all the public land, including all of the private land in the nation, and they tax it. In the Soviet Union, they don't need to tax it because in the Soviet Union, they own it all. In this country, they claim that you have ownership, private property rights over your land. Well, you can claim that as a matter of form so long as you specifically perform. Now, there are 15 pieces of real estate in the United States of America that are not on the property tax rolls, and those are called allodial lands or allodial properties. And so now, let me introduce Mr. Neelis Cook. And before Neelis takes the camera, let me just tell you a little about Neelis. Neelis has claimed 20,000 acres of the public lands from the, I believe it was the Agriculture Department, the Forestry Service. And he's done it legally and lawfully under the common law. And he has a common law claim on the land. And the federal government's been trying to get him off of it now for about a year. He's still there. And he's still exercising his rights. And he's challenging a federal code called the CFR that's been an established part of our federal bureaucracy since 1933. Neelis has two brothers who have also claimed land, a total of 56,000 acres of public land. Can public land still be claimed? Do you need your government's permission to claim unclaimed land? Do you have the right to use property? Can you use your car, your guns, your motorcycles in any way that you see fit? And if you can, how do you assert it? So let me introduce Neelis now, who's going to talk to you and give you some facts and figures on the subject matter of the private, or I should say the public lands that are being taken and claimed as private lands by private citizens.
Well, we're on property on this lesson. Property is a very important thing in this government system that we have here. The most fundamental element of a free society, said Thomas Jefferson, is the absolute ownership of property. And property rights form the fundamental basis of the Constitution of the United States. The whole reason the Founding Fathers said for forming a government was to protect the people's right of property and all the rights that are attendant thereof. The whole reason for having a government is to protect a man's holdings and to protect his rights to his way of life, to his endeavors, to his accumulations of property. And in order to do this, we formed a government, and this government was solely given the power to protect the individual and to provide for the security of the nation. And then there were added to this government, the Constitution, certain guarantees above and beyond that. And mainly, the Fifth Amendment being the most important on property, on the subject of property, which says that nor shall any man be deprived of life, liberty, or property without due process of law, nor shall private property be taken for a public use without just compensation. The absolute guarantees, then, of property in the Constitution were there for the reason of securing the freedom of the man, as Thomas Jefferson said. And the most important area of property, then, being absolute ownership of it in the law, is to be defined by the word allodium. In Bovier's dictionary, we find allodium defined, and of course they're quoting Washburn's Real Property, which says that allodium is an estate held by absolute ownership without recognizing any superior to whom duty is due on account thereof. And as we're talking about this, you might keep in mind, there is, in every county, as far as I know in this country, there is a property tax law. And I think that probably every owner of land in this country is paying real property tax. And this is an enigma in this age of constitutional government, when we supposedly had an absolute right of property. How can a man have an absolute right of property when he is paying an annual service or an annual fealty, if you will, to some superior? To go on, the term is used in opposition to fotum or fief, which means property, the use of which was bestowed upon another by the proprietor, on condition that the grantee, the man who holds the property, should perform certain services for the grantor, and upon the failure of which the property should revert to the original possessor. Now, does this sound like a service in the form of property taxes? One would wonder. But in the United States, the title to land is essentially allodial, and every tenant in fee simple has an absolute and unqualified dominion over it. Yet in technical language, his estate is said to be in fee, but that is a word which implies a feudal relation, although such a relation has ceased to exist in any form, while in several of the states lands have been declared to be allodial. And we're quoting a case out of the Pennsylvania Supreme Court called Wallace versus Harmstead, 44 PA, 494, I believe is the page. Also, there's a similar case out of Maryland and Massachusetts, and they are using much of Blackstone's commentaries and Washburn on Real Property. What we have here in this country, then, is an allodial land title, is the name of it. And allodial means absolutely no superior other than the owner. The outright and notorious owner is the superior, and he has the unqualified dominion over it. And that brings me to the definition of the word property, found also in Bovier's. I'll try to give you the citations for this so that these words are documented. Property, the right and interest which a man has in lands and chattels to the exclusion of others. It is considered an exclusive right to things. Property is a right, and contains not only a right to use those things, but a right to dispose of them, either by exchanging them for other things or by giving them away to any other person without any consideration, or even throwing them away. That's the Rutherford Institutes, page 20, I suppose. Also, we have 6 Bin, which is a Pennsylvania case, 98, that's B-I-N-N, and 4 Peters 511, Supreme Court report, 17 Johns, New York, 283. So therefore, that property is said to be the right which men have over the external things of the world to the total exclusion of the right of any other. And property is divided into personal and real property, and personal would be all movable things, and real would be land and that which is affixed to land. In the Idaho Code, the real property is declared to be lands, that which is appurtenant to land, such as water rights, etc., and that which is affixed to land, such as buildings, because they become a permanent fixture on the land. And if the man is the absolute owner, then why is it, one would wonder, that he pays any kind of fealty or service to a superior who has the ultimate right of ownership? Why would a man accept such a dominion which is so qualified as that he had to continually perform for someone else in order to retain possession, in order to live on a certain piece of land or farm it or use it? the county then, seen through this light, becomes a landlord. And the property ownership or property right under this law would become a feudal tenure, which is not an absolute tenure. It is only a qualified one, and is the man holds his property at the peril of his ability to perform and to keep this service rendered to the county year after year. The rights of property, though, getting back to the constitutional guarantees of the 5th and the 14th, are absolute. We have here a statement by the Supreme Court of the United States that the 14th Amendment was intended to protect those rights of person and property which by the Declaration of Independence were affirmed to be inalienable rights. It was in 1892 and stated by Justice Brewer. The Declaration of Independence tells us what? It tells us that property and life and liberty are inalienable rights, and they were granted by God, and they existed before government. And they were the reason why governments are instituted among men. Here we have a statement by another court. I maintain, therefore, that the security of the citizen against such arbitrary legislation rests upon the broader and more solid ground of natural rights, and is not wholly dependent upon those negatives upon legislation formally contained in the Constitution. It can never be admitted as a just attribute of sovereignty in a government to take the property of one citizen and bestow it upon another. That would be a taking of private property for public use, in essence, and can't be done without just compensation. The exercise of this power is incompatible with the nature and object of all government, and is destructive of the great end and aim for which government is instituted, and is subservious of the fundamental principles upon which all free governments are organized. I'm reading out of this legal quotations book, and I haven't found half of what's in here yet. This is some good stuff. Life, liberty, production, faculties, in other words, individual liberty, property. This is man. And in spite of the cunning of artful political leaders, these three gifts from God precede all human legislation, are superior to it. Life, liberty, and property do not exist because men have made laws. On the contrary, it was the fact that life, liberty, and property existed beforehand that caused men to make laws in the first place. And that's a quote out of Frederick Bastiat, The Law, and also 16 American Jurisprudence, 2nd, 356. Very good authority on what exactly a government is for. What have we done when we find that our government now is the landlord and has somehow legislated its own ability to take our land away from us if we don't perform according to its edicts? Justice Brewer laid down that the Declaration of Independence was the source of our rights, and we find that the 5th and the 14th Amendment follow right along in that same vein, as an attempt to secure to the citizen his absolute rights of property, not to be taken from him by an arbitrary act of government. Going back to allodium for a moment, the allodial land title is kind of a new name in American law, and it exists because somewhere back in England, a man had a land title that was allodial as long as he were privileged by the crown. In this country, we've removed that as a rule of law, and we have instituted allodial land titles as a rule of law in this country at the very founding of our Constitution, actually at the Declaration of Independence. And so we say that in the United States, the title to land is essentially allodial, and you have an absolute and unqualified dominion over it when you're the owner. Well, then one must ask, why is property tax paid? it would be totally consistent in my understanding that the state, if it wanted to, could tax property of a corporation. Pursuant to the Hale versus Hinkle doctrine, the corporation holds its entire life, so to speak, its entire existence at the behest of the state, at the grace of the Creator. Therefore, the Creator can take from it its just dues. In fact, the Creator can destroy and eradicate a corporation at any time it wishes, for any reason whatsoever. There's absolutely no guarantees, no rights of a corporation whatsoever. This is a rule of law in this country. It's axiomatic. So if the legislature wants to impose a property tax on corporate-held property, why not? There's absolutely no reason against it. One would wonder then how this tax came to be applied to the individual. Well, why do individuals pay income tax? Why do individuals suffer their policemen to exercise such totalitarian methodology out on the street? Why do we have men fawning at the hands of the legislature and hoping for privileges and hoping for more gains because of their lobbying efforts? I think that possibly slavery is the preferred state of mankind and freedom is only sought by the few. The state, however, has a burden upon it under the Constitution to protect property. This is the primary matter of state jurisdictions. Chief Justice Marshall once said that the states were bodies politic for the purpose of holding lands. In other words, the state government is the vehicle by which we hold our property, by which we secure our property rights, so that our children will be able to grow up on the land that we own, and they will be able to carry on with the fortune and wealth of their ancestors. The state jurisdiction is the primary and fundamental jurisdiction over substantive rights, which, according to the Erie Railroad versus Tompkins case in 1938, I believe that's 304 U.S., the common law over property is a matter of state jurisdiction. And the federal courts and even the Supreme Court must use the state's substantive laws when it makes its decisions. So you would check out your state constitution to find out what kind of property rights we have. I think George already had quoted our Idaho Constitution in saying that there's an inalienable right of the individual, of the man, to acquire, possess, and protect property. Well, if it's an inalienable right, then to have something, how can somebody come and take that thing away? How can any man come and take the property of another, even if he uses his legislature as the vehicle for doing it? It would not be consistent with the inalienable rights of property under our own constitutions. The Illinois case points out that a law or procedure is due process of law only when they do not conflict with the fundamental principles of law and justice, which lie at the base of all civil and political institutions. That's the U.S. Supreme Court in a case called Butte versus Illinois. The property rights, then, lie at the base of our civil and political institutions. The property right is the most fundamental right of all governmental action, all governmental activity, because it's for the protection of the government. It's for the protection of the people's property, the right of the people, that all government is founded, that it's given its power, that it is created in all of its branches and all of its instrumentalities. That has to be the primary aim. And yet what do we see? We see that after all this has been done over 200 years, we've had our governments in functioning all this time, we find that those very institutions that are supposed to protect our rights end up being twisted back around and end up taking the very rights that we sought to protect in the first place. This one statement then becomes very clear. artful politicians, artful political leaders, with their cunning, try to steal these three gifts from God, which are liberty, property, and life itself. And they try to precede these rights with human legislation, as if the legislature were superior to those very gifts of God that we sought to protect by founding the government. You can see the reversal of the end of government. Let's move on to a discussion of money and its relationship to property, because it just jogged my memory there that the ends of government are reversed by a paper money system or by a fraudulent money system. This is the words of Thomas Jefferson and others, that the founding of an issuing power of government to issue money and issue notes which they can declare to be legal tender become the very reversal of the ends of government. I think that's a clear enough statement that when this power is given to government and it's abused over a period of time, soon you will have the government stealing from the children the lands that their forefathers conquered and occupied, in the words of Thomas Jefferson. The function of money, then, is to give to the people a medium of exchange by which property can change hands. Instead of having to trade a cow for a sack of potatoes, which is an inequitable trade and an unfair exchange, you would have the benefit of a medium of exchange, which would be a fair and constant standard of quality, standard of value. The only kind of exchange that can be made then between two unequal quantities, such as a cow and a sack of potatoes, on the other hand, would be through a medium of exchange, whereby a man could get a large quantity of a certain thing for the cow and take part of that, a portion of it, and trade that for the potatoes, according to its value. So what should we have then as a medium of exchange? Well, all through history, man has used gold and silver coin. The governmental authority is used to coin money and to secure its constant value and true quality. In this country, the gold coin was based upon the silver coin, which was, as a dollar measurement, 371 1/4 grains of silver, and this was called a dollar in this country, and a dollar is nothing more than a measurement of weight. A dollar in the United States, then, by law, is declared to be 371 grains of fine silver, and it's incorporated into a coin weighing about 412 or 16 grains, whichever, and basically 90%. As long as it has that much silver in it, it is a silver dollar. So this then became the medium of exchange in America. It was declared by the Constitution to be the money in this country, and it was declared by the Constitution to be Congress's duty to coin money and provide its people with a medium of exchange by which property could change hands, by which property could be held and secured and paid for in the long run. So a medium of exchange is very important to the people, to their normal intercourse between themselves, and the money system becomes the vehicle for all trade and commerce. It's very important. Trade and commerce is the way that men acquire fortunes in many of the circles of life. There are those that produce from the land, and there are those that produce from the raw materials and cause industry, cause factories. And all of this would not take place were it not for a medium of exchange by which men could have a security of exchange. If money were to change value day by day, there would be no security. Each man would be, in effect, a gambler upon the present rate of exchange or the present value of his medium of exchange. And that's exactly the situation today with our very questionable, fluctuating, elastic currency, as they call it. So a gold dollar and a silver dollar then would tie down the market and would make it function the same today as it did tomorrow. The understanding of the Founding Fathers was that gold was portable land, one of their pet names for it. If a man sold a piece of land in New Hampshire and took the gold that he got for that transaction and went out to Illinois, he could basically buy the same value in land back. And he could then transport his rights to land across several states and buy, again, basically the same amount of property. And this is a great thing to be able to do. So money then operates as property. Money operates as property that a man can hold and carry with him. It's a very portable means of keeping your estate with you. If money is anything but intrinsic value, then it is subject to fluctuations, it's subject to fraud, it's subject to perversion, and there is no security to any property owner from that point forward. You can see from this discussion that our government, having perverted our money system for some 80 years now, has definitely destroyed property rights in this country. Probably the most fundamental wrong that's been perpetrated upon American people is this taking of the money system, this denying us a medium of exchange by which we can secure property rights. A man can make a contract today for $10,000 worth of goods, and in a year, if he takes delivery in a year, he's not going to get $10,000 worth of property. He's going to get its equivalent in checks or Federal Reserve notes, which have devaluated over that period of time substantially. The basic law, then, of exchange is quid pro quo, which is the old Latin verbiage and used in the English law for something for something. That's what it meant. It means that for a man to exchange property for property, he must give something in order to get something, otherwise he has robbed his neighbor. If he doesn't give an equivalent value, then he's getting something for nothing. If he gives a value that tomorrow will change, yet the thing that he got does not change, then he has also robbed his neighbor. Or his neighbor has become a gambler. Perhaps his neighbor volunteers into that. We don't know. But a sack of potatoes, I remind you, 200 years ago is still a sack of potatoes today. There's no difference at all. Yet the dollar that we all carry around in our pockets and think to be a dollar is not what a dollar was 200 years ago, not by the longest imagination. So the quid pro quo law of exchange has been violated. Men go around today and get X number of Federal Reserve notes for a day's labor, and tomorrow they want a raise. And they say it's because of the price of living. Well, what we have is just simply a devaluation of property rights constantly. So the property is no longer secure when you don't know how much you're going to be able to give or get for a piece of property, or how much you're going to have to give out of your own life and substance in order to get a certain property, such as the amount of food it takes to live. So the money system is actually the root of property rights. It is necessarily so because at one point or another you would suppose that all property would change hands and go through a medium of exchange. How are substantive rights of property to remain secure and to remain constant if we have no secure, constant medium of exchange? Perhaps this is the reason that we have the property tax today, that governments have been corrupted. Not only have we lost our money system, we have now erected a landlord over our estates, being the county. And what does the county do? Does the county actually come out and give us a service for which it requires a charge? Does it come out and spend money on our behalf and then simply ask its fair part back and ask us to pay our fair share? This is a question that should be answered. I've delved into this somewhat. I'm no expert on it, but at least we have the counties as an instrumentality by which loans are gotten, by which private debt can be secured. The counties have, at least in this state, an account with a nearby bank, and through this account they secure loans. They pay for the services, such as a road work or a school building. They pay for these with warrants or drafts or checks, and these are simply drawn on an account that they have established in the bank. What secures these loans? The thing that secures the loans is the indebtedness of the people to the county. And what secures the loans is the power of the county to tax the people and take back from them the payment for that loan. They pay the interest for the loan. They are paying interest to a private corporation. Well, the Ninth Circuit Court of Appeals in San Francisco decided just last June, in a case called Lewis versus United States, that the Federal Reserve System is a private-owned, privately controlled corporation, a system of credit and banking which is privately owned. So any credit given by them is private credit, and any interest paid to them then is private interest. Well, you may realize that at this point in time, if a county is giving credit or giving interest back to the bank, it is paying a private interest with public monies. It is paying a private interest out of a taxation, which is supposed to be for a public use. We have an Idaho Supreme Court case that laid down very clearly, there shall be no taxation for private uses. Private property in the Constitution can be taken for public use, but not without just compensation. Well, there's another question that needs to be answered then. Is the county doing right by securing a loan? Does the county have the ability to do that in the constitutionality of its true powers? Does it have the ability to go to a bank and to secure a loan with a performance of the people in using the land and the other property of the people as a security for that loan? Does it do that with their consent? Does the individual property owner out in the community there, does he give his consent specifically, or is it simply implied because that's his government, so to speak, that's doing it? These are all questions that should be answered. I don't think that there's a scrap of legality to the entire system of counties taxing the people on their property. I'm not even sure that they can tax the corporations. And here's the reason. Even though a corporation owes its entire existence to the state, the county is supposedly offering services to corporate business, among others, and then is demanding a charge back, a recovery for that thing. If the county has never spent any money out of the treasury, then how can it demand anything back? The fact is that the counties have simply written checks, which are bills of exchange, and they're not even good bills of exchange, and has claimed to pay out of the treasury these monies. Actually, the counties have not paid out any monies. They have not given bills of exchange. They've not secured any goods to the people who do these jobs, such as build a road or a school. The counties then are fraudulently misrepresenting the state of affairs and are using the taxing powers to rape, rob, and pillage the people. Exactly. Taking the land for no cause, taking the land when there's been no compensation paid. The whole money system has given them the opportunity to do this. The system of Federal Reserve banks with their unlimited credit flow allows the county to not even use the treasury, to use the bank as its treasury, and to use credit as its funds. It has no funds in actuality. The people pay in by check or by Federal Reserve note. These are deposited in the account, which is no more than notations in a book or on a computer, and then out of this the county pays out, quote, pays out its obligations. Actually, no payment is made. All we have is claims given on property of the people. A claim gotten on a man's property with no due course of law and without his consent, then, is theft. It's extortion, plain and simple. So the property tax is a sham. The property tax is illegal, I think, even as it applies to a corporation's property.